So were there, let me ask you this, were there any big surprises that happened during trial other than obviously the infamous drone footage that was not exactly handed over uh in exactly as an exact copy, I should say. Aside from that, because there's obviously so much interest in hearing from you on that, partly because of how handily you, if I may say, you kicked ass on that. So many people were so impressed by that. So we'll talk about all
before
of that.
we get into that, as I do want to say, and as I do know the difference between a megabyte and a millibyte, I was very nervous. And
100%.
in general, my family's a medical family, so I default in my head to thinking like milligrams for things.
Okay.
So, and so that was just kind of nervous in the moment misspeaking, but I do know what a megabyte is.
Yeah. No, I saw that when people learned that that I was going to have you on the channel for this interview, I know that there were a bunch of people that were like, "Hey, it's Legal Millibytes," like this kind of collaboration, which is fun.
Well, and that's one of the reasons I also had like reached out to you, is because I thought it would be fitting. I was like, bites, like it feels like kismet. So
absolutely, 100%, I agree.
And
we're
I
the
saw
same
somebody
age.
in the chat. Yes, we are the same age, but I did correct myself more than once. Somebody just said I only corrected myself once. I did more.
No,
but no, we are the same age.
Times. Yeah, and like
we're
roughly
33.
roughly same amount of experience outside of law school and whatnot. So it's nice. It's nice having another conversation with another lawyer that is, I'm a little bit on the younger end in comparison to most of the LawTube crew, which is fine. They're great. They have so much experience that I can learn from. But anyway, so other than the drone footage, were there any other like surprises that came up during trial that you guys didn't anticipate?
Yeah, tons of stuff. I mean, the issue with Jumpkick Man, obviously. And that is something, I'm not going to stick up for the prosecutors here. As you said in the beginning, I do want to maintain my professionality and things like that. But Kyle had mentioned this, I believe, in his interview with Tucker, we did not know who Jumpkick Man was until during the middle of the trial. And the state says they didn't. I don't have any reason to doubt them. But, I really don't know. It's not anything I have personal knowledge on. What happened with that was, I don't remember what day it was exactly because it's kind of all a blur. But the prosecutors called us I don't remember if we called into the back at that time or not. But they had said that somebody claiming to be Jumpkick Man had come forward. And the state hadn't even met with him yet, hadn't confirmed whether or not he was Jumpkick Man. We had a name, and then we had a copy of a booking photo. And we thought this might be this person, but in the videos, he is wearing a mask. So we didn't really know for sure if this is. It could, with something like this, the amount of crazy people who are coming out of the woodworks, I don't think anybody knew whether or not to believe this was Jumpkick Man until we actually talked with them. And originally, because he was a complaining witness or victim in the situation, the prosecutors wanted to meet with him without us. We had a big problem with that because he'd been, MIA and just surfaced during the middle of the trial. If we didn't want us there, then we wanted one of our investigators there, and they didn't really want that. But Judge Schrader was kind of just like, no, that's not how it's going to be. Like, he offered to have himself moderate a meeting with everybody, but the prosecutors didn't want to do that. And we didn't really want to do that either. So what ultimately was determined was that the meeting the prosecutors were going to have with him would have been videotaped. The whole thing, we would have instantly got a copy of it, My understanding, at least the information that we were provided, was that the state never actually met with the person claiming to be Jumpkick Man, because beforehand, he, through his attorney, had told them, The only way he's willing to even meet with them is if they agreed to give him full immunity for anything he did that night and the crimes he was charged with previously. And they weren't willing to do that. I mean, they didn't really even know if it was him. I mean, I think it was him, ultimately. But they didn't actually meet with him, to my knowledge.
Okay. Interesting. So when that knowledge came up that he had been, I guess, identified during trial, I mean, what did you guys think about that?
I think I don't know if he was identified or that he came forward. I don't know. It was something that the whole time I was very skeptical. We were all very skeptical of, because I mean, Kenosha is not New York City. Like, there should have been somebody who was able to identify him beforehand. And we were very skeptical of the fact, we were saying that the whole time is, we were referring to him as being a, non-complaining witness, unknown witness. I mean, I would have a hard time believing that this person didn't know about everything before the trial, at least to some extent. At least that, because it was everywhere in Kenosha.
I mean,
somebody would have
across the
identified
United
him.
States even.
Yeah, somebody would have identified him. So
yeah, that's very strange. And then the same thing, I know that there was also a controversy about the Ziminskis, right? And being able to bring them on. So were you guys, remind me, were you guys trying to get them on as witnesses as well, or?
Well, there's a big problem with the witness list in this case is, I mean, I think the first witness list, I don't remember if it's the first witness list we got or the second. I mean, I could look back, but there were, approximately 180 people on it. And of course, they're not going to be calling all of those people as witnesses. We then got and Jumpkick Man was not on the witness list. His name, because I personally went through each and every person on the witness list previously, and I made a chart with their relevance, things like that. And we got a short list from the state with, identifying who the people they thought they were that they were actually call. We didn't get that until not too long before the trial. And then we got a supplemental short list with doubling the number of people, like a week and a half, 2 weeks before trial. But, the Ziminskis were on the state's witness list. They were never on their short list of people. We had them both under subpoena and, basically on standby the whole trial in case we thought we needed them. But there's a lot more than just what's in the media about the Ziminskis. And, you don't ever want to call a witness who might distract from the issues or is not going to serve you in some way. And there wasn't anything from the Ziminskis that we couldn't get from other people.
Makes sense.
So
I guess it, correct me if I'm wrong, it sounds like it didn't really hurt your case too much to not have them.
No. And I mean, if we had them ready, if we had felt it was necessary, but there are a lot of, like I said, chess game. There's so many factors that are involved in this. And so much of it does involve the jury. I had the best seat in the house for watching the jury. I was literally facing them the whole time. And, I believe in Joel and Demetrius, who's an amazing person who I would love to talk about in a little bit. She was there with us and she's done a little bit of an interview, at least that I'm aware of. I don't know how many since then. And, she's described a lot of them as being poker faced, but she also unfortunately didn't have the vantage point I was in. So there were obstacles sort of in the courtroom that were impeding the people in the gallery from seeing certain things. Like there was that big TV that, people were pointing to and stuff while they were talking to the jury. And part of the problem was just the space constraints in that courtroom. Is there are certain things that can't be moved because of it just being a very old building and having to try and fit all this stuff and these people in here. I mean, they're if we could have moved some things, there would have perhaps been better use of space, but that's not how the courtroom was designed.
Right.
So, like that big TV, I think impeded a lot of people from like seeing different parts of the jury. But, like I said, I was facing them the whole time, and there were some people who were poker faced the whole time. I mean, there's one woman specifically that I'm thinking about who the only time I saw her really give any type of genuine reaction to anything was actually when Ryan Balch was testifying, and she smiled at him. She liked him a lot.
Oh, interesting.
Yeah, but she didn't respond to anybody else at all. She was, yeah. So
that's an odd one to
yeah,
like, if any of them, I would think.
Yeah, she liked Ryan for some reason. And so much of it was little things like that, is, wanting to make sure that each person had it. If each person's connecting sort of specifically with one person, regardless of what they're poker faced and the rest of the time, it kind of does inform, your analysis of how things go moving forward. Because there were, so many things that you don't anticipate. Like, we had a medical examiner who was ready to testify, but Mark was able to successly use Doug Kelly against the state. So
for all intents and purposes, he was your medical. Yeah, he was your witness.
why do we need to call our own when there's the risk of them using him against us? Because you can never anticipate what somebody else is going to say, and regardless of whether or not, working with experts in general is very odd. I don't know if not a lot of attorneys don't have experience with it if they do, contractual things like that. But, to an extent, there is working with experts is an art, and there wasn't anything that we thought our expert that we could get out of him that we didn't already get in a more theatrical way with Kelly.
Now, your video expert, as you said, it's an art, directing an expert witness, because so much of what they talk about is so technical. And so, not only do they have to have obviously the know-how, the understanding of what it is that they're talking about, but they have to communicate it in a way that a lay person would understand. So with your video expert, to me, that one seemed like, did you guys get thrown off by having to rearrange things before he took the stand? Or
no? Well, there were. You're talking about like physically rearranging the courtroom, or
no? Because there were certain portions that I think Binger, if I remember correctly, Binger successfully objected to, and so you guys had to like rename certain things, and so it seemed like things sort of got maybe disorganized in the direct examination.
Mark really is the person to talk to about John Black's testimony. The part of the problem with that is, he had originally been hired to be our use of force expert, and we had our Daubert hearing, that we went through. John did his testimony on that, and then the state responded to that with their expert. And we didn't even have that full hearing. As you remember, we were wrapping things in with John's testimony with time, because, there was some criticism over, why would you stipulate to having any of John Black's testimony limited? It's like, well, there was a benefit of that, is because then they couldn't bring in somebody.
Yeah.
And and if you've seen their expert's report, it was just ridiculous. And, you don't want to, and it's a pros and cons, cost benefit analysis type of situation.
Of course.
And, John Black with his testimony, the issues with renaming things like that, I don't think really ultimately had any effect on the cross-examination. Part of it is, again, just dealing with experts, and they get very, very technical about things. And if you don't ask they take their oaths seriously. And, sometimes it's hard to get what you want out of them because you're not phrasing the thing exactly the way they want it phrased. So, I don't think that it was anything extreme with that. I think it was more asinine little changes.
Okay.
But the things about like the identification of the file name, stuff like that, I mean, they were used as reference points. It was, I mean, irritating to have to change those because it's like, oh, you've been calling something an apple and all of a sudden you have to call it an orange even though it's an apple. But I don't think that the jury cared about any of that, any sort of, any type of friction that there might have been.
Right. So was there ever, because I remember when we were commenting on the live stream on Ricado Law's channel, we were talking about the possibility of you guys not even needing to put on your own case in chief. Was there ever any kind of a discussion about doing that or limiting further the witnesses that you guys put on?
Oh, we did limit significantly the witnesses that we put on. There were several people that we didn't call because they weren't necessary.
For example, the medical examiner you mentioned.
Medical examiner, our investigators. And I want to take a minute and I want to thank Todd Johnson and Steve Spagnola. Those are our investigators. They are both phenomenal men. Steve is a former Milwaukee homicide detective. Todd is a retired Long Beach homicide detective. They were the only people who were involved with, really the only people involved with the original, who were there before us, rather, who stuck around, who we kept, because they were both very good at their jobs and very good, and were very, very helpful to us. Those, for example, we didn't call them. We had digital experts. We had a bunch of other things that were ready, but a lot of it involves whether or not people make certain concessions on the stand. And so, there were a lot of concessions that were made by people. So, we did limit ours significantly. And also, part of the disadvantage of being the defense is you go second. And there were some times in the state's case of chief that dragged on a bit. And and a lot of it honestly is optics when you deal with a jury, is they don't want to listen to a witness that doesn't add anything.
Right.
And,
because at the end of the day, I mean, they want trial to end too, so they can go home and go back to their lives.
Yeah. I mean, and this is also, I don't know if people watched voir dire. I know you couldn't see the people and I don't know how well things were microphoned, but somebody during voir dire, said out loud, this is a situation where there's really a win because both sides are so, opposite from each other. And considering everything that we were putting jurors through by being there, it's a respect for them thing too.